In the Bryan Kohberger case, it has now been 3 weeks since I submitted my request to unseal some documents. We still haven't heard. I guess the judge has been a little bit busy.
The state has been arguing about capital punishment, and we're going to see what our viewers have to say about it. I'm Lainey Law.
And I'm attorney Andrew Myers.
And obviously, as a defense, you're not going to want your client to have this looming doom of capital punishment. And it's hard when things like that vary from state to state. But looking at it in this case, it's now turning into what seems like a mountain of paperwork.
Yeah, and not only in a recent hearing in Boise, Idaho, did we see kind of between the tea leaves how the judge might rule on all the capital punishment issues. I mean, and it's always dangerous to guess what a judge might do because you just don't know. More important than that issue in my mind, because I'm not sitting in the defense chair, was the relationship between the new court and the new judge and all of the attorneys. There were 3 attorneys on both sides, and we really hadn't had that much of a chance before to really see how this judge is working with these attorneys as opposed to the judge back in Moscow, Idaho. So they launched into a 4-hour-long, with a lunch break, argument over whether the capital punishment will be abandoned before the trial and or all the aggravators. And as you probably remember from a previous episode, we had the defense raised 13 motions to strike the death penalty, and the prosecution came back with 14 motions objecting and a couple of other things, and all of that was argued before Judge Steven Hippler in Boise, Idaho. And it went on for about 4 hours. And the relationship between the judge and the attorneys was a little bit different than it had been in Moscow, Idaho. So we start out with a portion of that hearing in which Judge Hippler and Ann Taylor argued over capital punishment's application in the Kohberger case. Hippler saying that the defense claims it violates the 8th Amendment, but the law requires that if they want to go forward with that, they really need to come up with some alternatives, and he really pressed her on that.
We represent Mr. Kohberger, who sits there an innocent man right now, but we're preparing this case as a capital case with all of the things that involves, all of the requirements that are upon counsel that take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction, and if there was a death sentence, and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional? If he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then? Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
And so the two, Ann Taylor and also Jay Logsdon at times, the defense attorneys and Judge Steven Hippler went back and forth, the judge seriously questioning all of their motions. And he Judge Hippler suggested that he could just deny them all.
Now, I have a quick question. He specified it's going to be 10 years until anything happens. Why was that? Why would he say that?
Well, look at the case of Thomas Creech. I mean, he was first pegged back in the 1970s, and they're just getting around to a second attempt at executing him now, November of 2024. Appeals take forever.
Well, I don't know. It's weird to me. I don't know. I just thought that stood out to me to say, because it's just like, obviously, like logistically, it does take a long time, but that seemed just like very specific to point out that it's going to be such a long process anyway. And then why not argue about it later down the line?
Yeah, well, that's pretty much what he was saying was that, if one of their arguments, if one of the defense's arguments is that it's cruel and unusual punishment under the current technology, then why are we arguing about it now? Because we don't know what the technology will be like in 20 years. Remember, Jay Logsdon at an earlier hearing had said this might not happen for 28 years. Remember that? So pertinent to this is the execution of Thomas Creech. Pertinent to this is the Thomas Creech case. Remember, they tried to carry out the DP on him. It failed after they tried to inject him 8 times and failed. Since then, my understanding of it is that they now have a whole new process which involves a deep injection into a central vein. Well, the judge actually discussed this. And in answer to your question, I mean, who knows if it'll work the second time? Who knows? Maybe in 28 years, if Mr. Logsdon is right, or a decade from now, if Judge Hippler is right, who knows what the technology will be? Or who knows? Maybe someone somewhere will just say, "Okay, guys, knock it off. Let's just not do it anymore."
So I understand his argument, and I think you do a good job at presenting it. I think it's just a stupid argument on his part because we don't even know if they are going to change. So it's like you're putting it on the trial right now. And like you said, we have all these failed attempts. That would be considered inhumane. Like imagine this person's trauma of needing to go through all this procedure again. So even though things will change, or could potentially change, you can't really argue for potentially the future versus right now. In her argument, it's inhumane. But yeah, I understand that this whole court case has to happen in the first place to even argue about it, to justify it.
I think what you just said, I think that's Judge Hippler's view of the whole thing. This was first of all, the case was dumped in his lap. So, and I'm not defending him at all. I have all due respect to the bench. What I'm saying is I don't think he was happy to have this case dumped in his lap to begin with, and then to have 13 motions and 14 objections dumped in his lap where he's required to hear them. And he demonstrated a great deal of patience in the hearing that he presided over. But I think this was one, and we're going to see another, this was one of his ways to just kind of say, guys, really, you're forcing me to decide this? Because don't forget, no district court judge wants to be overturned on appeal because that's not a good day for them. And if you have 13 motions and 14 objections, chances are pretty good you're going to have something that you do that the appeals court is going to take a dim view of. So
I will just say, in Ann Taylor's defense, my jaw would be on the ground, so annoyed if he's telling me that I'm going to have to worry about dealing with this in 10 years, because I'm sure she wants to be done with this a year ago.
Oh, you really think so? You really think so? I mean, these are the kind of cases that do stick around. So the judge pretty much said he could just come right out and deny all of these motions.
Doesn't speedy mean the Barker test?
Well, at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker test.
Again, I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
So he's kind of giving him a heads up. If I wanted to, I could just deny all these motions. One of the defense's motions argued that Idaho's capital punishment law violates international treaty, and that was an argument that Judge Hippler pretty much denied out of hand.
We're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
falling, I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
Well, Your Honor, it's an argument, and it must be made.
That's not something you ever want to hear a judge tell you, that your argument is falling flat. I mean, that's not something you want a judge to say to you in open court. You'd rather have him say, I'll take it under advisement and then go and leave the bench. But so I think we kind of know how that went. I kind of felt bad for him when that was said. But again, as we've said before, these motions were pretty much made to preserve the record in order to be able to bring this up to the Idaho Supreme Court and also the United States Supreme Court. So that's what takes so long. That's what could take the 28 years that Jay Logsdon was saying initially. So I don't know. Towards the end of the hearing, the judge was listening. At one point, he appeared to be looking down and writing something. He was, and as though he wasn't listening, and he was already writing. Now, I don't know whether he was writing his grocery list or whether he was writing out his ruling. But at one point, he was looking down and not even listening and just kind of writing things down. But so that's how that went. And it seemed to me that this judge was very professional. He was listening. He was actively arguing. He wasn't just like sitting back like I think a lot of people felt the judge in Moscow, Idaho was doing, just kind of sitting back and indecisive. And in the end saying, yeah, get it out, get it off my desk. So that was what was important, I think, about this hearing.
He was definitely actively participating. It reminds me of how my mom is an attorney, and it kind of just felt like they were like teenagers asking to go out, but they didn't do their homework, and that they were kind of having the law laid down on them. It's just like, your argument's falling flat, this isn't working out. So it like kind of makes your skin crawl a little bit watching that, because it almost feels like they're in trouble as that's going on. From my perspective, as just someone watching it, it just, even like he was being logical and he was being reasonable, and I think he was being a good judge. It just didn't look good for the defense in that moment.
No, you really don't want to judge. A lot of times a judge will give you cues, or a judge will ask you a question while you're making an argument. He'll give you cues. One of them could be, well, what about this other argument you're making? Or let's turn to page 28 of your brief. That rather than just telling you right to your face, your argument is falling flat, because we all know what that means. I wonder what our viewers are thinking about this. We've gotten some really interesting comments from our viewers in recent episodes. We've been watching Kohberger, since the beginning, but more so now that it has moved down to Boise, Idaho. So let's take a look at some of what our viewers are thinking. This is a lengthy comment that we received, and this person said, law enforcement originally stated that the murders happened between 3 and 4, and that timeline was stated after the surviving roommates were interrogated, shortly after the M's were fresh in their memory. Law enforcement also had their phone data to go over and still maintained that timeline. The coroner agreed with that original timeline at first. Law enforcement used the same data and then changed the timeline weeks later to between 4 o'clock and 4:30 a.m. based on a white car, a thud, and a dog bark. Then they added the story of a masked man, which surely Dylan Mortensen told them that story early on, yet still the timeline stayed between 3 and 4. So if the timeline is off, law enforcement have no case, even with the touch DNA.
There's no evidence on video that a white car sped away around 4:20 since they based that assertion on the loud sound of a car supposedly speeding away at a high speed since there's no video of such to substantiate that assertion. Kohberger would have had to be in and out in 8 minutes, plus no DNA found in his car or apartment. That alone would be highly unlikely. The original timeline may be the correct one since no victim's phone was in use after 3 a.m. The DoorDash order has not been established to be given to a live person, and Xana's phone very well could have been looping from that 2:53 phone call to DoorDash, as Ellie stated. Xana most likely alive and on TikTok at 4:12 a.m. and most likely is not conclusive.
I thought that was a good comment, a very, very insightful comment, taking a look at everything. And we've talked about that timeline before, way early in the case, how we really didn't think the timeline of the number of minutes that he would have had, whoever it was that committed these crimes would have had. It doesn't make sense. And so, Kay Hawkins, thank you for that one. This one's from Michelle, and she says she's from the replay crew, which is fine. That's the great thing about YouTube. You don't have to, it's not like the old days in TV when a show was on at 7:00. You better be there at 7:00. You got to miss it. Michelle says, replay crew here. Great stream. Enjoyed the guest a lot. That would have been Kevin Curtis, the attorney. You are right about people being solidly in two camps with this case. Question, when it comes to the genealogy, can family volunteer their DNA, and will we know in trial which family members donated, or will it just be inferred? By the way, it always pains me to see the house demolished. Allowing jurors to walk through it would have been helpful to put living spaces into perspective. Well, going forward, that is, you put your finger on an issue, and that is, can family members opt out of having their DNA used? And yes, they're supposed to be able to select that. The issue is whether the providers then go along with that when they receive a subpoena. And they're supposed to, but that's an issue that has not been answered affirmatively. And then, we've talked about that. Was it a good thing to knock down the house? No.
And I will say, like, with the allowing jurors to walk through, it would have been helpful. I definitely think that makes a huge difference, too, because even just something as small, like yesterday, I was working at a place that I wasn't used to working at. And as I stepped out, I didn't realize there was like even just like little bumps, so I almost tripped. And it's things like that can make a huge difference that you wouldn't necessarily think of even just looking at like a replica of the house. And this is like a question that I have about like the touch DNA, because this person's talking about family members volunteering their DNA. If Bryan Kohberger is in custody, can they just take his DNA?
Yeah, they did.
Okay.
Yeah, they did, and it matched. And so that's why the prosecution is backing away and saying, this is irrelevant. We're not even going to use it, because that's exactly what they did. So, but it's still a big issue. It's still an issue, and it's an issue that Ann Taylor is pursuing.
Great vid. I especially like your Be Kind segment at the end. Everybody is fighting something. Be kind. You may best someone with a much needed smile from user with a bunch of letters. And we definitely do try to be positive, and we deal with some sensitive topics, and it's can be hard at times, but people have strong opinions, and we need to have a way to share them respectfully, because in situations like this where we don't have a verdict, we don't know what happened, we don't even know what evidence is there, we can't really be saying things like for certain or making character judgments on these people and the victims families and things like that. So we try to keep it respectful here.
I don't know if you saw the answer. I try to answer as many of these as I possibly can, but I obviously can't answer all of them because we get so many. My answer to this was that I stole the Be Kind to Everybody in the grocery store and the gas station from another podcaster. I stole, it's okay to steal ideas. You can't steal the actual thing. That's a copyright violation. But here, I stole the idea from a podcaster who I have invited to collaborate with, and I was ghosted. So no apology rendered. The next one is from Slacker. Florida always seems to have a high-profile trial, but they're still able to be completely transparent while ensuring the integrity of the case. Social media is not going anywhere, so they need to adapt. I think it's the best thing that ever happened to our justice system. IMO slacker. And you know what? Obviously, they're talking about the judge in the Sarah Boone case, who was a fantastic judge. He stopped, explained himself, allowed documents to be put up on the screen and discussed, and the videos. It all went in. He at one point, arguments were made on one evidentiary issue, and he said, I'm going to go off the bench because there's some cases I need to take a look at before I make my final decision. So he was honest about it. He wasn't 100% sure what the case law was and what it said. He went out, there was a break, the jury got their smoke break or their Twinkies break. Everybody came back, and now he had a decision, and he explained his decision. So, Lainey, you're the expert at this stuff. Yeah, social media is not going anywhere. It's exploding in my view.
Yeah, it's definitely just the new version of like the cable, for example. It's just like before everybody used to gather around the TV and watch the programs, and there were certain programs that everybody watched. And social media now is where people go to get their news. And, it sucks too from the court's perspective, because if you're a judge, it's not easy having everything that you're doing being observed and people making judgments on that. But I do think it's important to have transparency in the justice system and making sure that it's as easily accessible as possible.
Yeah, exactly. So let's see. Do we have another one? Yeah, we have one more. It's yours.
No, didn't Bryan Kohberger have interviews with Moscow Police Department? Don't you think that Payne or another officer could have left that transfer touch DNA themselves? Transfer DNA alone cannot find the person guilty of M, but the PCA has been found as worthless. There's no proof of that a white car was BK's car, and the defense will show that during the trial. The lost video of his car must be exculpatory, as they aren't showing any video that BK was seen driving in the area of the 1122 residence. Such transfer DNA does not prove beyond a reasonable doubt to have been put there by the person whose DNA was transferred to that sheath. There is no blood, saliva of BK at the house, nor any hairs, blood, or of victims in his cars or apartment from Karen G. And that's, one of the weird and crazy things about the DNA situation. Obviously, like, I'm not a forensics expert myself, but
you're not. I thought you were.
My expertise is I'm hair technology, forensics, but that's definitely what I've understood from the touch DNA itself, is that you can just touch a paper and then that person brings that paper into their room. What if the sheath is on their paper?
Yeah, exactly.
There's too many aspects.
And in a previous episode, we did a deep dive into 2 cases in which convictions were overturned in part due to touch DNA. And that court in Connecticut actually cited to some scientific journals that are available online that say that, the touch DNA technology is an evolving one, and it should not be used alone in court in order to base a conviction on. So, a lot of people have just said his DNA was in the house. End of story. No, it's not the end of story. That's a pet peeve of mine. I don't like when people say end of story or period or that's it, because you know what? In the law, there's always more. People come to me and say, oh, this is a slam dunk. And I tell them, no, it's not.
And it's also like things like touch DNA. Like, I have long hair. And my hair, anybody with long hair can attest, your hair is always shedding everywhere. You go into the shower and there's like clumps of your hair coming up. You could go to a gym and one of your hairs is on the ground. Somebody steps by it on their sock, and then your hair is also in their house. So even if they had found a hair, like, there's still so many variables in that kind of situation.
Well, if you want to get into that, I have a dog and a cat. Lily, the illegal beagle, has appeared on our podcast in the past, and she will in the future. Her birthday's coming up, but my dog and cat are both black and white. So you can't win. Right now I have a pair of black slacks, and I'm sure if the forensics people looked at them, they'd find black and white dog hairs all over them. But,
I have a dog hair right here now that you said that.
Touch DNA is not reliable, and the courts have said that it's not a reliable thing to base convictions on. And there's just so many questions in this case that, again, I did submit a request to unseal some things, and others have done the same. Some have heard back that it was rejected. Mine hasn't been rejected yet. Maybe that's just because it's on the bottom of a big pile. There were two other comments that we got that I wanted to mention. One of them was somebody said, they thought that these IKEA shelves behind me might collapse. An engineer used to occupy this office before and he bolted them to the wall. So they're actually bolted. If you look behind the shelf, I wanted to move them one time. No, they're not moving. When I leave this office, they'll still be there. So they're not going to be leaving. And now I forget what the other one was. There was another comment that I wanted to address. Oh, I know what it was. Somebody said, an attorney said unaliving, that's it, I'm done. And it's like, how do we explain that?
Yeah, I had that same thought. And I'm sorry to cut you off, but I was just thinking, it's just like, we say it because YouTube's going to censor us. They were like, I'm not watching you anymore because you're not saying that. I'm like, well, you wouldn't have watched us if we did say like the actual word, because YouTube wouldn't have shown you our video because we said that word.
Right. And there's all kinds of words we can't say. There's a funny YouTube out there somewhere. Remember George Carlin's 7 dirty words? Well, there's actually a YouTube out there, 233 words you can't say on YouTube, and it's hilarious. It's really just, I can't repeat the 233 words for obvious reasons. And you can guess most of them, all right? They're George Carlin's dirty words and their permutations, but then there's more and more and more, and it's hilarious. And some of those words you wouldn't say anyhow, the stuff we're saying. But yeah, so the point is that I think Yoli said that very early on in our episode with her recently, and it's like, I remember when we first started doing these, I'm like, I didn't know anything at all about YouTube. I knew nothing. Not that I know a whole lot more now, but I'm like, why are these people saying unalive? That's not even a word. And then I realized that you can't say certain words, and I don't get it. I don't get it. But I mean, I guess it's because, the advertisers don't want to, and I remember back when I was in broadcasting many, many, many years ago, not that it's real, a lot of things changed, but I don't think this has changed that much. Sometimes you do a story and sales would come into the newsroom and say, why did you say this? Why did you do a story on that? Why are you, talking about this or that or the other thing? Because the advertisers don't like that. How can I sell, Joe's Auto Sales or Harry's Carpet Company if you're reporting on stuff like this? And it's like, it's news, that's why. But so there's always been that tension, and I would bet you anything that it's still going on behind the scenes. Not that it really affects bona fide news, but it does kind of affect stuff. So that's why we reluctantly, and now even though I protested the word unalive, even though I protested that, I catch myself saying that sometimes.
Yeah, no one hates unalive more than Andrew.
I know, I don't. And so when Yoli said it, I didn't say a word because, the new thing now, like as you've noticed, a lot of people say M, first degree M, or in Sarah Boone's case, second degree M. One word that people are somehow getting by, and maybe I shouldn't even say it because it won't be good anymore, is red rum. Mm-hmm. Red rum, because it's the M word backwards, which I guess you can get away with now. I don't know.
And just talking about rum is somehow more appropriate.
I guess we'll find out.
It's like this video's ding. It's like, you'll know. It's
a couple of our shorts. A couple of our shorts have recently gotten the thumbs down because we said stuff, and I haven't gone back and looked at them. I haven't gone back and looked at them and figured out why, but they were on. And just maybe the mention of him, I think maybe just the mention of him is like objectionable.
Well, there was a certain letter that was used as an abbreviation, and when I was making captions, that letter turned into I don't even want to say the letter.
I know what
because
we
didn't even say the word. Andrew said the first letter of the word, and it filled it in. That's all.
Yeah.
There's no winning.
That's a dangerous. I mean, that story deserves coverage, but it's really difficult to talk about without violating rules, standards, morals, codes. I mean, I remember just scripting it. I thought I had screened all the bad stuff out, but I guess not. I mean, I looked at the indictment and I read some of the news stories, and then I sat down and I wrote the 2 shorts out, and I thought I was following the rules, but I guess.
We try our best. We make videos. I'm glad you guys appreciate them. We're trying our best to get them out to you, but one bad word gets us suppressed and demonetized and all types of issues.
And on that note, I suppose we should say have a great day. Do you have any closing thoughts? I don't.
No, I mean, ultimately, this whole situation is going to keep on developing. And it's going to be interesting seeing the judge's further interactions with the state and the defense. It was a little bit rough in this clip today. It did feel like we're watching people get almost scolded. But I do think that overall, I think it's good that the judge seems engaged in the case.
Looking ahead, my prediction is that the DP motions, they're all going to either be denied or placed on hold to a future time. And the thing to watch out for in the Kohberger case in the coming months as the snow takes over the north of America, the thing to look for is motions in limine and motions to suppress. And there will be a lot of arguments. And unfortunately, we'll have to take a look on how much of that is going to be sealed, because after all, if they're looking to suppress evidence or to keep evidence out in a motion in limine, I would imagine that if the judge is of the same ilk as Judge in Moscow, which I don't think he is, if the motion is going to be successful to keep evidence out, they wouldn't want to get it out. Oh, one other thing. Did you notice somebody missing from that hearing? William Thompson was not there.
Oh,
Ashley Hush Jennings was there.
I noticed Ashley for sure.
Ashley Hush Jennings was there, but Bill Thompson was not there. And on that note, thank you for joining us. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.